The BC Supreme Court will soon be ruling on a constitutional challenge that may very well change the face of healthcare in Canada. Dr. Brian Day, the founder of Cambie Surgery in British Columbia, is challenging the laws that prohibit doctors from billing patients privately for procedures covered under publicly funded Medicare. He is also arguing that doctors should be allowed to charge patients user fees and to practice in both private and public health systems. Colleen Flood, University of Ottawa Research Chair in Health Law and Policy, explains why Dr. Day is contesting these laws.
They're saying that these laws are unconstitutional. They're in breach of the Charter of Rights and Freedoms because people have to wait too long for care. And because they have to wait too long for care, some people experience further ill health. They suffer as a result. Then these people would be able to buy care more quickly in the private system and they wouldn't have to wait on a public healthcare system list.
What would be the consequences of a successful challenge?
If Dr. Day and Cambie Surgical Services are successful in their claim, then in every province the law that bans extra billing would essentially be struck down because we're talking about the Canadian Charter of Rights and Freedoms.
A decision in favor of Cambie surgery could have far-reaching consequences and may not be the best way to improve access to healthcare in Canada, fears Colleen Flood.
I think many Canadians might hear about this case and think, great, because we've got to do something about wait times. This is going to fix my problem with wait times. But it probably won't for most Canadians because unless they're able to afford the care out of pocket or they qualify for private health insurance, Dr. Day and the Cambie Clinic are not making a claim that all Canadians should have timely treatment, just the Canadians that can buy care in the private sector. So it's not trying to make the government provide timely care for all Canadians. It's just saying, government, get the hell out of the way so that we can let a two-tier care system flourish.
Before deciding on the fate of Canadian healthcare, both sides will have to demonstrate the state of the healthcare system across the country and the impacts of allowing more privatization. But Colleen Flood believes that the court is not the best place to be debating such an important health policy.
So the evidence in this area is difficult because it's actually quite difficult to do the sorts of studies that we need to fully appreciate what the connection is between the laws that ban extra billing and the laws that require doctors to opt in and out and wait times. So what we will have is a dueling battle of expert witnesses between Dr. Day's witnesses and the government's witnesses. It's not a scientific process. It's not the best process that one would want for making this kind of high-level policy. And I think we will want to try to make sure the court appreciates just how far this could go if they rule in favor of the applicants.
She adds that the court should not necessarily look at the healthcare systems in other parts of the world to make a decision regarding Canada's own system.
Those kinds of simple comparative analogies that the court did in Shauli, I think we are much better placed now to help them understand that that kind of comparison is very poor, very weak, doesn't stand up scientifically, that it's much, much more complicated than that.
The Shauli case that Colleen Flood mentions is a judgment from the Supreme Court of Canada in 2005. It ruled that Quebec's ban on private insurance for publicly insured healthcare services violated the Quebec Charter of Human Rights and Freedoms. Although this case set a precedent in Quebec, the BC Supreme Court can not only rely on the evidence presented in the Shauli case to come to a decision for the Day case, she explains.
What we do know now from Shauli to this time is that we have to do a much, much better job of presenting what evidence there is to the court, to explain to the court how complicated healthcare systems are and that we can't simply look at the French healthcare system and assume that, the French healthcare system has a greater role for private finance and seems to work okay, so Canada could have a greater role for private finance and it would work okay.
After many delays, it appears the case will go to trial in May and should last for several months. The decision, whichever way the judge rules, will likely be appealed and eventually heard by the Supreme Court of Canada. For Evidence Network, I'm Mélanie Meloche-Holubowski.